Hello, everybody, and welcome to yet another installment of our Friday lectures. And today we have the immense pleasure to welcome Professor Kristina Daugirdas, who is the Francis A. Allen Collegiate Professor of Law at Michigan Law School. I always get a little bit bogged down by those front names of the US chairs, but it's Christina has been a very, very inspiring and inspired scholar in the field of international law in a broad sense, but more specifically in the field of law of international organizations. And she has been tackling lots of foundational conceptual issues involving how international organizations are bound by the law, how international organizations contribute to lawmaking, but also, as if that were not enough, she has been conducting some cutting-edge empirical research in the field of organizations, basically producing some very important data sets, and also looking into issues of institutional design and such. So you could not have a more rounded scholar speaking to you today about Interpol in an era of rising authoritarianism, international police cooperation. And without further ado, Kristina, the floor is yours. It's really, really a treat to have you with us today.
So thank you, Fernando, for that very kind introduction. It is such an honor and pleasure to be here with all of you this afternoon, especially because what I will be presenting this afternoon is genuinely a work in progress. So it is not a finished product, and I'm really eager for your comments and for your questions. So as Fernando said, the title of my lecture this afternoon is International Police Cooperation in an Era of Rising Authoritarianism. So the starting point for this project is that across time, across space, authoritarian governments have demonstrated a large appetite for international cooperation to target their political opponents abroad. So the very first modern police organization, the Police Union of German States, was established in 1851. The union's members were 7 German-speaking states, including Prussia, Austria, and the union's express purpose was policing the political opposition of established autocratic regimes. On the ocean during the 1970s and 1980s, military regimes in South America participated in a secret scheme known as Operation Condor to coordinate their efforts to suppress what they called subversion. And more recently, an analysis by political scientists of 29 hard authoritarian regional organizations, characterized as such based on membership of those organizations, found that 25 of the 29 were engaged in police cooperation. And over the last 15 years or so, authoritarian governments have increasingly turned to Interpol to target dissidents and political opponents abroad. Interpol is an international organization headquartered in France. It has 196 member countries, so its membership rivals and even exceeds that of the United Nations. To understand what Interpol does, I think it's helpful to separate out 2 distinct stages in international police cooperation. So step 1 is locate and arrest suspects abroad. Step 2 is to extradite or use some other means to bring them back home. Now, contrary to the way that Interpol is sometimes portrayed on TV or televisions, Interpol does not itself undertake investigations or chase suspects. Interpol is mostly, but not exclusively, a communication tool. And from early on in its history, these communications have taken particular color-coded forms. The most famous, of course, is the Red Notice. So Interpol Red Notices are requests from law enforcement to law enforcement worldwide, specifically to provisionally arrest the named person pending extradition, surrender, or other legal action. My slide shows a press release, a 2021 press release, where Interpol proudly announced that its notices led to the arrest in Mumbai of two of India's most wanted fugitives. So Interpol's involvement is really the preliminary part of step one of what I described, communicating information about wanted individuals. It's national police forces that do the arresting and detaining. When it comes to step two, there are generally separate legal frameworks that govern extradition. Bilateral treaties are the most common, but not the only legal framework for extradition. And this is a place where the practice of states has really split across the globe. So extradition treaties to which democratic states are parties typically contain exceptions for what are called political offenses. These exceptions enable host states to decline extradition requests when the requesting state is seeking a person or an alleged offense was committed for political reasons. The origin of these provisions, dating back to the mid-19th century, is that liberal states did not want to facilitate the persecution of fugitives from oppressive regimes. But of course, these political offense exceptions did not appear universally in extradition treaties. For example, extradition treaties between former communist countries did not include such exceptions. And today, there are regional organizations that have treaty frameworks relating to extradition that don't include such provision. So two examples include the Commonwealth of Independent States, the Minsk Convention on legal assistance that was negotiated under the auspices of this organization. It has it facilitates extradition. It includes some exceptions, but nothing like a political offense exception. Similarly, the Shanghai Cooperation Organization has also been the forum for negotiating multiple treaties that facilitate extradition and that don't include anything like this political offense exception. So coming back to Interpol and how these two steps fit together, there are many, many examples in recent years of authoritarian governments issuing red notices for political opponents or dissidents. Sometimes they're arrested and then extradited pursuant to the kinds of agreements that I just mentioned. But I think it's important to realize that red notices can be effective tools to harass dissidents, even when they don't result in extradition. So the existence of a red notice can make it harder for named individuals to do things like find work, to travel freely, to rent property, to open bank accounts, and to normalize their immigration status. In addition to these material consequences, red notices can also serve an important symbolic function. Authoritarian governments will frequently cite Interpol red notices as proof of an international consensus regarding a named individual's guilt. Now, of course, Interpol will say over and over again, these Interpols are not a determination of guilt. Also, it's not Interpol that's seeking someone, right? It's an individual member country of Interpol, but those misrepresentations are quite frequent. So let me give an example. In 2017, Joanna Conley, a Turkish-German writer, was arrested and detained while vacationing in Spain on account of an Interpol red notice. His case got high-level attention. Even Angela Merkel criticized Turkey for abusing Interpol in connection with his case. That high-level intervention secured a Conley's prompt release. But that wasn't the end of the story for him. He couldn't go home to Germany. He had to stay in Spain for 2 additional months registering weekly with the local police department whilst being awaited and then processed his extradition request from Turkey, ultimately denying it. Now, I want to be very clear that Interpol has not been passive as these examples of abuse have mounted. It has strengthened both ex ante and ex post review of red notices and other communications to make sure that they comply with Interpol's rules. So I'm going to get into the details of the rules a little bit later, but just to flesh out what these new and more robust institutions look like, ex ante review is done by a portion of the Secretariat that is now known as the Notices and Fusions Task Force. This task force is a dedicated interdisciplinary team. It's composed of lawyers and police officers and operations specialists who have skills in many different languages. They're charged with undertaking a quality and legal compliance review to make sure that incoming requests for red notices and other communications comply with the rules. There's also a possibility for ex post review, and this is done mainly by an independent body called the Commission for the Control of Interpol's Files. And this is a body that individuals can approach, individuals who believe that they are or they might be the subjects of Interpol red notices or other communications, can approach the Commission for the Control of Interpol's Files and request a correction or a deletion of any data that Interpol holds about them. So what's happened over the last dozen years as Interpol has ramped up its protections and its reviews, authoritarian governments have innovated. And so it's a cat and mouse game with repeated cycles of pursuit and evasion. So Interpol tightened up red notices, authoritarian governments pivoted to diffusions, which are less formal communications that go through the Interpol networks, tighten up the diffusions, and the abuse moves to blue notices, which seek information about location rather than rest. Then they moved from there to the lost and stolen travel documents database. It turns out that reporting somebody's passport as lost or stolen is a pretty good way to strand them abroad, sometimes separated from their families for extended periods of time. So this cycle has been ongoing. Now, the U.S. government, in a 2024 report that was co-authored by the Department of State and the Department of Justice, took the position that the problem had been basically solved. So as you can see on the slide, in the most recent report, which was completed under the Biden administration, the position of the U.S. government was, although instances of member countries misusing or attempting to misuse Interpol notices and diffusion still occur, this particular form of transnational repression seems to have receded. I don't yet have a good grasp of the Trump administration's approach to Interpol, but President Trump is going to great lengths to use the U.S. legal system to go after his political opponents and perceived enemies. And so it would be an understatement to say that this is inauspicious as a signal of what the administration's approach to Interpol may look like. So I'm worried, and my main concern is that I have doubts about the sustainability going forward of Interpol's efforts to curb abuse by its authoritarian members. And by extension, I think Interpol is a case study that raises bigger questions about the viability of police cooperation through a universal international organization like Interpol. For a long time, there's been a widespread view, or maybe a widespread assumption, that obviously international organizations should strive to be inclusive, that they should strive for universal participation. And some of them clearly should continue to do so. But I have become less sure that this is the correct approach across the board. So let me say a little bit more about what these trends look like at Interpol. Fernando mentioned that I have been doing some empirical work. Some of that has involved collecting information about the member states of international organizations over time and using that together with data that is produced by the Varieties of Democracy Institute to characterize those states at a particular point in time as democratic or authoritarian on a scale that runs from 0 to 1, where 0.5 is the widely used cutoff between democratic and authoritarian states. So let me unpack what's on this slide. The pink line shows the proportion of Interpol's member states that were democracies in each year since 1956. 1956 is the year that Interpol adopted its modern constitution. And I appreciate these numbers may be a little bit small. This is the 50% line. And so if you just look at that bright pink line, you might be a little bit puzzled, right? Why is this problem of abuse of Interpol a problem that has spiked in recent years when in fact there's this stretch of 4 decades where barely more than a quarter of Interpol's states were democracies? We're maybe still falling off here at the end, but it's not like it's a dramatic cliff. So what's going on, right? So of course, raw numbers only tell you a part of the story. So here's what this pink line obscures about the first 4 decades of Interpol's history. The major communist states were basically absent from Interpol during those first 4 decades. There was no Soviet Union. There's no People's Republic of China. China was represented by Taiwan. There were no Eastern European satellite states. There's no Cuba. So the Cold War, the defining conflict of that era, just didn't really manifest at that organization. And Interpol, for this reason, in an important sense, was not a universal international organization during this part of its history. I think another part of the story here that's important is that many authoritarian states during that era are newly independent states emerging from decolonization with democratic institutions, but then quickly sliding into authoritarianism. And this is a generalization in a place where there's more digging to do, but based on what I have found, these states were not especially active participants in the organization during this period. And then the last thing to note about those decades at Interpol did not start out as a standard issue international organization. It took quite a number of years for it to start walking and talking and quacking and being accepted as an international organization. And in the meantime, as the host state, France was really playing a dominant role in the organization. In its early years, the staff was overwhelmingly French. France either supplied the headquarters or supplied the loan for the headquarters. And so it took some time before Interpol was an international organization in the sense that we think about them today. So that's kind of the first 4 decades. What about period right? If we look at this period after the 90s, where Interpol becomes roughly evenly split between democratic and authoritarian states and slightly more democratic. Why is this downturn maybe more of a big deal than it looks? So this is the map from the most recent version of the Variety of Democracy report. Based on the VDEM's Liberal Democracy Index, 2024 was the first year since 2002 that there are more autocracies than democracies in the world. There are, of course, different ways of defining and measuring democracy, but this basic trend is shared by other metrics that you can find. The other thing is, if you look at the numbers, not just counting up states, but taking into account population and taking account GDP, the decline in democracy is even more dramatic. Weighted by GDP, 2024 is the worst year for democracy in more than 50 years. So another way of putting this point is that the decline in democracy are being driven by states that are more populous and that are economically stronger. There's a separate shift that political scientists have observed in rhetoric over the past decade, which is that authoritarian states have gone from mimicking democracy and trying to sweep under the rug the gaps between the rhetoric and the reality to much more openly challenging democracy's normative appeal. So if we go back in these global trends to what's happening at Interpol, and now I want to focus on mine on the top. So one measure of influence within an organization is the election to leadership positions. So Interpol has a plenary body, a General Assembly, in which all members are represented, operates by one state, one vote. This alternating red and blue line on top shows the proportion of democracies among Interpol's 13-member executive body. And the line alternates between red and blue based on the state from which Interpol's president comes. So Interpol's president, it's mostly a ceremonial role, but it comes with some modest authorities to chair meetings of the General Assembly, chair the meetings of the Executive Committee, oversee the implementation of their decisions, and be a liaison to the Secretariat and the Secretary General. So what can you see over time, right? For the most part, the Executive Committee has been a little bit more democratic than the General Assembly as a whole. But in the last decade, there's an uptick and then a significant decline in the proportion of democracies on the Executive Committee. And 3 of the last 5 presidents of Interpol have come from authoritarian states. Recently, the Russian candidate who came from an interior ministry that was widely regarded as an abuser of Interpol came within a hair of being elected president before ultimately losing. Interpol's member states also select the Secretary General. It's a 2-stage process that involves a nomination by the Executive Committee and approval by the General Assembly. The most recent elections took place in 2024. The insider candidate who had played a key role in developing protections against abuse of the red notices lost resoundingly. It was not even close. And of course, there's a lot going on in these elections, but still, that outcome is revealing. Finally, in terms of influence, I want to mention that authoritarian states are becoming increasingly significant funders of the organization, both through assessed and through voluntary contributions. So that's sort of what's happening among the member states, I want to pivot now to the legal text that governs Interpol's work. So this is the 1956 Constitution, which has been amended over time, but the provisions that we're going to focus on have remained the same. So Article 2 sets out the purposes of Interpol, which are to ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of the laws existing in the different countries and in the spirit of the Universal Declaration of Human Rights. Second, to establish and develop all institutions likely to contribute effectively to the prevention and repression of ordinary law crimes. If we go to Article 3, it sets out a series of prohibitions that have been understood to define what an ordinary law crime is not. So Article 3 says it is strictly forbidden for the organization to undertake any intervention or activities of a political, military, religious, or racial character. So when Interpol, really when Interpol was being reestablished after World War II is when this language became a part of its constitution. There were a few goals that were animating the drafters. One was to facilitate police cooperation without attracting attention from national governments and especially foreign ministries and diplomats. So this is one reason why Interpol's constitution, not a treaty. It's an informal agreement. It's a reason too why if you look at Article 2, right, this is cooperation within the limits of the laws existing in the different countries. Interpol is not a source of new international obligations on member states, right? We're doing this. The idea was we're doing this with the authorities that we already have. There was also an effort to distance Interpol from a World War II interlude where the Austrian headquarters of Interpol were taken over by the Nazis, moved to Berlin, and what happened after that was murky. But again, the revival was an effort to resume police cooperation in a way that created some distance, and a reference to the Universal Declaration on Human Rights was a way to do that. Now, of course, there are lots of questions based on this text about how to draw the line between ordinary law crime and everything else. And the General Assembly was at least intermittently active in helping to determine both what this text meant and what the procedures would be, right? Who gets to do the work of interpreting it? An early 1950 resolution said, in line with many bilateral extradition treaties, that, okay, you've got pure political offenses, right? Think treason. You've got ordinary law crimes, right? Private actor against private actor, life or property. And then there's the stuff in between that has some elements of both. So in 1950, the General Assembly said, well, what matters is what predominates, which did not provide so much guidance to the Secretariat, but it did communicate to the Secretariat, look, you shouldn't rely on the characterization of the requesting state. You should do some investigation here to evaluate what kind of crime we're looking at. The other thing that happened is that over decades, the General Assembly adopted resolutions that interpreted these prohibitions in Article 3 more and more narrowly. So the General Assembly said, well, we would like Interpol to help with terrorism, notwithstanding the political elements that are often a part of it. we would like Interpol to help with war crimes, with genocide, with other serious international law crimes that, again, are not so easy to characterize as ordinary law crimes. So this effort to sort of constrain while expanding Interpol's mission is one way to try to limit abuse, but it only gets you part of the way, because if the core problem for abuse is the government's motivation going after someone, it's easy enough for a government official to say that someone who is wanted for political reasons committed something that is unambiguously an ordinary law crime. So to go back to the earlier example of Joanna Conley, the Turkish government said, we're going after him for armed robbery. Interpol's approach continued to evolve over time. In 2007, Interpol took a new approach that was codified in a set of rules on the processing of data that were adopted by its General Assembly. And these rules on the processing of data, the key provision for our purposes is Article 34, compliance with the organization's institution. Article 34 gives a set of factors to consider when evaluating whether a particular communication is consistent with the organization's constitution. In particular, it's Article 3. And these are instructions to the Secretariat, which is making this assessment in the first instance. So the key factor that I want to focus on is G, the general context of the case. Because there's a lot of action here, the general context of the case, this is where anything and everything, including especially a state's motivation, can come in. This is the place where a request can be considered in light of a pattern of abuse over time. This is the place where the human rights situation and the requesting state can come into play in evaluating a request. So lots can come in, right? Everything can potentially come in as general context. So what about the question of when the general context of the case outweighs these other factors? Like, this is all there is. There's no guidance on how to weigh different factors. And so on that question, the rules on the processing of data give zero guidance. And so on the one hand, you might look at this and say, that is actually essential, right? If we want to be able to police motivation, you need to have a provision like this. On the other hand, the way that this is drafted, Article 34 makes the decision that when it outweighs other factors an act of discretion by Interpol's General Secretariat. The decision is inevitably based on a value judgment of what should be given greater weight, right? This is like any multi-factor test in the law, where judges or others are instructed to consider a list of factors. They're not like they're apples and oranges, and so how you weigh them against one another is left to the individual to determine. So I think this situation is a real challenge for the Interpol Secretariat. So from its very founding, Interpol has insisted on the importance of being perceived as a neutral organization. And in this, Interpol is unique, right? Every modern international organization insists that it is neutral. And I want to unpack what neutrality might mean here. I can offer up a few different ways of defining what it might to be neutral. And the challenge for Interpol is that these definitions are all either unavailable to Interpol or very uneffective. So first possibility, right? Neutral in the sense of deploying technical value-laden expertise. As I mentioned before, there's no doubt that the task force is made up with individuals with considerable expertise, right? Legal and police and otherwise. And this certainly helps them flesh out all these different elements of Article 34.3. But expertise doesn't tell them how to weigh the elements against one another. And so neutrality as expertise, I think, is not available to Interpol. There's a second possibility, which is neutrality means don't second guess or pass judgment on your member states. And this position was taken by one of the early secretary generals of the International Criminal Police Commission. So this was before Interpol was renamed Interpol in 1956. But the language of Articles 2 and 3 was almost identical to what I showed you. So in 1950, immediately before the adoption of the resolution I told you about that said, Interpol, look at what predominates. Czechoslovakia wanted the International Criminal Police Commission to disseminate arrest warrants for individuals who had hijacked an airliner and forced it to land in the West sector in West Germany. Czechoslovakia said, they're obviously criminals, they're hijackers of civilian aircraft. This is what Interpol is all about. The United States said, per J. Edgar Hoover, this is a case of refugees from a communist regime using a legitimate escape. Louis Duclos, the Secretary General at the time, said, the organization has to disseminate these communications, even if they're controversial. Any other decision would have implied a political judgment on the case by the ICPC in contravention of our statutes, right? Remember Article 2 and 3, that's precisely what we don't do. What happened is the U.S. and Czechoslovakia both withdrew, the U.S. for a period of 8 years, Czechoslovakia for several decades, right, as part of that exodus of communist states. But I would point that this position is one that has been articulated from Interpol's earliest days. The second quote that's on this slide, it is the position taken by the Turkish Interior Ministry in the Akanlı case. So remember, I told you Angela Merkel said, Turkey, stop abusing Interpol. And the Interior Ministry's response wasn't to sort of shrink away and quietly pretend this doesn't happen. The Interior Ministry said the problem is Interpol, not us, right? Interpol is not following its own rules in this situation. So this interpretation I'm going to file as available, but unattractive. So a third possibility. The third interpretation of neutrality acknowledges, yes, international organizations deal with values. And yes, international organizations inevitably have to take controversial action that runs counter to the preferences of at least some member states. And the most forceful articulation of this comes from Dag Hammarskjöld, the second UN Secretary General. He gave a famous lecture at Oxford defending the concept of an international civil service. In that lecture, he was responding in part to a quotation from Nikita Khrushchev, the then Soviet premier, who said, while there are neutral countries, there are no neutral men, right? The suggestion was this idea of a neutral international civil service is impossible. And Hammarskjöld, this is actually from a press conference sometime after the lecture, sort of summed up, I think, a key point of his position, which is, look, I'm not required to be neutral about everything in this job. I have to set aside certain preferences in the same way that a judge in a national court has to set aside certain preferences. But there's nothing that says I have to be neutral about the charter, right? There's nothing that says I have to be neutral about the facts, right? A respect for the truth is still a crucial part of what it means to be an international civil servant. I think this vision of neutrality is much more attractive, but I think it gives Interpol insufficient guidance. So Interpol's constitution and the implementing rules that we just discussed, I think are too indeterminate to provide the anchor to say, no, all we're doing is following the values of Interpol constitution. I think those texts just replicate the question about where to draw the line between ordinary and political crimes. I think the imperative of standing up for the truth is certainly applicable to Interpol. There's a place, though, where Interpol's fact-finding capacity is quite limited. So attractive, but its available to Interpol, I think, is quite limited. There's a board possibility, right? We are neutral in the sense that all we are doing is implementing clear rules adopted by member states. So why not get the General Assembly to adopt some clearer rules and depart from this totally open-ended analysis that we see in Article 34? My best guess is that there's a stalemate in the General Assembly that the Secretariat has been trying to manage and has been trying to manage. So I'm going to say more about why, and I want to be clear that this part of the presentation is maybe especially speculative. I'm reading between the lines, and during the Q&A, tell me if you think I am overreading an omission. So here's the omission that I have in mind. The General Assembly of Interpol has not adopted a resolution that explicitly states, look, we're going to delete any notice, red notice, other communication about any individual who has received political asylum. This omission, I'm focusing on it. I think it's surprising because Interpol has said we have had such a policy for at least a decade. So secondary sources say that the executive committee adopted such a policy in 2014, although the substance of that decision policy not publicly available. One other thing to note about 2014 is one of the, right? It's one of these spikes in how democratic the executive committee was. So this was an unusual year in which 3/4 of the members of the executive committee were democracies. In 2015, Interpol officials described such a refugee policy in various meetings, including one with the Committee of the Parliamentary Assembly of the Council of Europe. And that committee issued a report that said, this is great, right? Cheers to Interpol for having such a policy. It would be super nice if they published it somewhere public, like on their website. And so today, if you look at a portion of Interpol's website, I've got the link here, that is captioned Interpol Refugee Resolution, you'll find text that looks like the policy, right? Once a member country has confirmed a person's refugee status, Interpol will delete any notice or diffusion for the individual from the country where he or she fears persecution. So sounds good. It's public on Interpol's website. And the referenced resolution is also available on that website. And that resolution says in the subject line, this is a resolution about Interpol policy on refugees. This resolution is not at all about protecting refugees from abuse of Interpol. Instead, this resolution is about mounting concerns that dangerous criminals and terrorists might try to abuse the refugee protection system. And nearly all of the provisions in this resolution are geared to that end. And then there's this opaque language at the bottom. So the General Assembly endorses the guidelines contained in Report GA 2017-86 Rep 10 with regard to the processing of data related to refugees and asylum seekers. This report is not publicly available. So what exactly the General Assembly endorsed, it's not possible to verify as an outsider. But what one can see as an outsider is that the deletion of red notices for individuals who have refugee status and have received political asylum remains controversial. So another example that got a lot of political attention, this one concerned Dolkun Issa, the former president of the World Uyghur Congress, an organization that is headquartered in Munich. So Issa grew up in China as a student in the 1980s. He was an activist in the Uyghur community focusing on literacy issues. After an arrest and several encounters with Chinese authorities, he left China, first with Turkey and then for Germany, where he was granted asylum and became a citizen. Issa first learned that he was the subject of a red notice for murder in 1999, said in an interview, "I was shocked because I have never even killed a chicken." Over the years, he encountered various problems traveling internationally, but he was never extradited. He was always able to return home to Germany. In 2016, Issa planned a trip to India to meet the Dalai Lama. India first granted and then revoked his visa. This got a lot of attention in media, which suspected that India was buckling to pressure from China. The media attention also prompted some NGOs to reach out to Issa and offer to help him seek removal of the Interpol notice through the Commission for the Control of Interpol's Files, that ex post body that I mentioned earlier in my talk. He succeeded on his second try. And when he did succeed, the Chinese government was quite upset. So the quote on this slide is from a press release issued by the Chinese Foreign Ministry. Says China expresses its dissatisfaction at Interpol revoking the red notice for Dolkun Issa. Dolkun Issa is a terrorist as determined by the Chinese government. And then a minute, I find this odd. If Interpol's policy is so clear-cut, you would expect, maybe you would think that China would be upset about the policy, but it's surprising to be upset about the outcome in a particular case if there really is such a clear-cut rule. The other thing about this case, so usually the decisions by the Commission for the Control of Interpol's Files are not made public. In this case, part of Issa's decision was reproduced in a recently published book. And the analysis, if you look at what the Commission wrote, the Commission said, even supposing that the crime described is an ordinary law crime, the Commission considered that there's a predominant political dimension in this case and that the information supplied by the Chinese National Central Bureau does not satisfy the requirements of Article 3 of the Constitution of Interpol. So I didn't underline it, right? But there is a predominant political dimension. This sounds like we're weighing all the factors, we're taking them into account the way that you might expect under Article 3 for 3, not we're simply applying an easy, straightforward rule that certainly applies to this individual case. So the outcome aligns with the policy on Interpol's website, but the analysis suggests we don't have a clear-cut rule. And I think the absence of a categorical, clear rule adopted by the General Assembly here is a pretty important signal of where at least some of Interpol's members are. So Interpol is in an unenviable, difficult position, wedged between a rock and a hard place, right? This organization is under pressure from all sides. As a group, its member states have an uneven commitment to preventing abuse. They don't even all agree on what counts as abuse. And at the same time, given the constant ammunition in the way that authoritarian governments are engaging in transnational repression, to stay on top of this issue, Interpol staff needs to be alert and forward-leaning. I think looking ahead, while the General Assembly doesn't seem to be able to adopt a resolution that would, for example, clearly protect refugees, I think it's also unlikely that the General Assembly will adopt measures that would dismantle or obviously hobble Interpol's current approach to addressing the issue. I think the real risk comes from more subtle and less visible means of influencing Interpol's work. So the task force and the Commission for the Control of Interpol's Files have always had limited resources for a big job. The most recent stats I found are from 2020, but in 2020, with 30 staff members, the task force reviewed 11,094 red notices and 13,618 wanted person diffusions. During that same year, the commission, which met 4 times for a week at a time, it's not a full-time body, examined 1,594 requests. So the task force and the commission are vulnerable to being still further starved of resources. I think it's also easy to imagine quiet instruction, right, from the new Secretary General, a future Secretary General, to the task force to, hey, like, just dial it back a little, right? Don't look so hard into the general context. Don't weigh it quite so heavily. The consequences of that are quite difficult to perceive from the outside. So Interpol publishes some numbers about the number of red notices of other notices that are rejected by the task force. What does it mean if those rejections fall in number? Is it that states aren't trying, or is it that the task force isn't catching it? Right? You can't tell from the outside. So take all this together, I think that democratic member states need to keep asking themselves, does police cooperation through a universal international organization remain a good idea as we get further into the 21st century, especially if the current trends of democratic decline continue? This is a genuinely hard, if uncomfortable, question. So with that, I will wrap up, and I very much look forward to your questions and comments.